Right. So, so let me ask you this: as a mediator in New Jersey, so do they have?
Hi, my name is Sydney Mitchell.
Hi, I'm Matthew Brickman, Florida Supreme Court mediator. Welcome to the MediateThis podcast, where we discuss everything mediation and conflict resolution.
Good morning, John.
Hey, how are you?
I'm doing good, sir. How are you?
Not bad. We were supposed to have a nice sunny day and a nasty thunderstorm is coming through right now. So hopefully, hopefully everything is good. We had one the other day that knocked out the power for 4 hours. So
Well, that's not good.
no, I know you're in Florida, right?
Right.
You guys are used to these thunderstorms all the time. We're not used to them in New Jersey, and our infrastructure can't handle it always.
Yeah. Yeah. In Florida, at least where I am, they've put most everything deep underground. So we don't have the toppling power poles and the lines snap and that stuff, which is nice because yeah, when that goes, you're just sort of cut out from the real world.
Oh yeah.
Yeah.
Well, I'm
So
from Texas, so sort of used to it, but you know, still kind of.
yeah, yeah, I had read that on your bio that you grew up in Texas. So you're in New Jersey. You're an attorney and also a
Yep.
mediator in New Jersey, right?
Yep.
But you grew up in Texas, went to Texas A&M, and where? So where in Texas did you grow up?
Houston.
Oh, Houston. Okay, I've got family there. I've got family in Houston, and then also in Dallas Fort Worth area.
Oh, that's nice. Yeah, I have live family everywhere. I'm actually my most of my family live in the Texas Panhandle, so they're mostly cattle ranchers and like people that are not close to being attorneys. Let's put it that way.
Yeah. Okay. So a lot of so great grandparents, cousins, stuff, they're all up in the Panhandle. Where in the Panhandle are they?
So, so like my parents are from Pampa,
Okay.
which is kind of about an hour northeast of Amarillo. So
Okay.
I was born in Amarillo. I lived there
Okay.
for like, very, very early years. But most of them are along the Oklahoma, Texas border. They have huge cattle ranches, and
Okay.
I like to say it's very Beverly Hillbillies.
Yeah. Yeah. We yeah. So we've got family in Lubbock. And then my great grandparents, they were farmers. They were in a little town called Olton.
I've heard of
Um,
all.
yeah, and so we used to spend our summers there with them when we were kids. It was fun.
Yeah,
But
no. Lubbock, my entire family went to Texas Tech. I was the first one to break out of that mall and go
okay,
to, and I went to Baylor, and then I went to
okay,
A and St. M. But yeah, I'm very familiar with Lubbock, and
yeah,
whenever the wind shifts, you smell manure, and well,
yeah.
it's great. It's a great, yeah,
So
yeah.
much different than New Jersey. So what drew you to being an attorney, and then how did you get to New Jersey?
So my neighbor growing up was an attorney, and he went to Seton Hall in New Jersey. Um, and I don't know, I knew I wanted to get out of Texas, so I applied everywhere, and I didn't get into NYU in Columbia as I had hoped, and Seton Hall was right across the river, and they gave me a full ride, so I was like, let's go. Uh,
Great.
so that's how I got here. I thought I was going to be in New York City. I
Okay.
thought that's where life was going to take me, but then I clerked for a judge in New Jersey, and then I started working in divorce and family law. Not what I set out to do ever. Um, and then I kind of got just sucked into it, and then I started doing mediation about probably 12 or 13 years ago. So
Okay.
I was about 12 years into practicing, and I decided litigation wasn't for me.
Okay.
So yeah. So my firm, we kind of, I have attorneys that litigate, and I take on the mediation. I do I mediate probably, um, I'd say on average, I do about 3 to 4 mediations a week, something like
Okay.
that.
Okay.
So, and I love it. I absolutely love it. The feeling of getting an entire divorce done in like 3 or 4 hours for people makes me just so happy, just so happy. 'Cause I
Right.
know
Right.
how much I just saved them in terms of time, aggravation, emotional distraughtness, and money. I mean, it's like great.
Right.
Yeah.
So, so, so let me ask you this: as a mediator in New Jersey, so do they have a? Is it an appointment? Is it a certification process? Is it a licensing? What do they what do they do for like? Hey, John wants to become a mediator. What do you have to do for your mediation Is it a certification? What do they do with that in New Jersey?
There's no certification. You don't have to have any credentials to be a mediator here at all. None.
No,
Mm-mm.
like wow,
No, I
none.
mean, none. I mean, you could just put out a shingle and say, I'm a mediator now, and that's sufficient. I mean, it's like, I guess it becomes a little bit more gray when you start. I mean, as a mediator, you can't give legal advice, but when
Sure.
you start doing anything that's remotely legal in nature, you might start to, run up against unauthorized practice of law type of arguments. I could see that happening, but I tell everyone the same thing. You really need an attorney as a mediator to make sure you don't miss anything, make sure you've got someone guiding you, to make sure you dot all your I's, cross all your T's. And I draft settlement agreements. I know this is a big, huge
I know
argument
it's a huge thing, right?
yeah, but I draft them. I draft them because the point is to save people money. Like if I'm just going to draft an MOU that they're going to have to take to attorneys to then spend, thousands of dollars fighting about an settlement agreement, I didn't really accomplish my goal.
Correct.
So, and I fear if I draft the settlement agreement, I tell them go see an attorney before you sign it, and they choose not to, I've done what I need to do to, and I've learned how to draft them. I'm sure if you do this, you probably have too. I mean, I learned how to draft them without making them. I'm making them as neutral as possible. The language is neutral. I don't add in anything extra. I just say exactly what we agreed to, but I make sure it's sufficiently clear, adding in detail where necessary to make sure it's sufficiently clear. Yeah. So, and then we get them divorced. Like after they sign the agreement, we get them divorced. We do conflict waivers, and we just go ahead because once they have a signed agreement, it's
Yeah.
paperwork basically. So yeah,
It's a contract that now just needs to be submitted to the court so they can have a stamp and it's now an approved court order.
exactly,
Yeah.
exactly. But people
And it's
here,
uncontested.
not everyone here agrees with me, and we started doing a flat fee program, all kinds of
Okay.
different flat fees, and the attorneys here are losing their minds at me right now. But I'm like, what? Because we're saving people money, and they're not putting them through that ringer. I don't know how much the average divorce is in Florida, but in New Jersey, it's around $15,000 to $16,000 a person. That's
Yeah.
about what it is. And I mean, come on, a family shouldn't be spending $30,000 for most divorces. Come on, it's ridiculous.
Yeah. And it is that here in Florida. I mean, they say the average is about 8 to 20. So yeah, it's within that realm. Now in Florida, to become a mediator, there is a Florida Supreme Court certification course. So with county and civil mediation, it's a 20-hour course. And then you've got to do a mentorship. So it's done like on a point system. So you have to hit so many points. So like, if you're an attorney, if you get so many points. If you've got a master's degree, if you speak another language, second language, you get points. And so all of that goes towards your points, but you still have to do a mentorship, which is good.
Yeah.
And then once you do the certification course, once you then do your mentorship, then you can fill out, you can submit your application. Fine. Now you're ready to start. For then family mediation, dependency mediation, appellate mediation, circuit certification mediation, those are all 40-hour courses. And then it's all on a point system. You get your mentorship done, and then you can start. What I find is that it's almost impossible to do family mediation without understanding the law. And just like you said, like a lot of people, like I'm going to hang a shingle and yeah, I'm a mediator. Okay, do you even know how to read a statute? Do you know what the law even is? And in Florida, a lot of family mediators come from either the legal world or the mental health world. And sometimes, and yeah, this is something I think you sort of alluded to it because you said, you were an attorney, then you're not really wanting to litigate, and you really like the idea of mediation. I have found like I work with a lot of attorney mediators where they're an attorney, but they dabble in mediation. And sometimes that switch from advocacy to neutrality is a difficult switch. Like, did you find that in your, when you were starting to do the transition, or were you just like, I don't like this advocacy trial? I really like the neutrality. How did you resolve that?
Well, what's interesting about that question is I do think that as an attorney, you're either built to be a mediator or you're not, because it's very similar why I don't think retired judges make particularly good mediators.
That is so true.
Well, I mean, once you're like you're advocating, or once you're like used to making a decision, it's hard to come in completely neutral. I have this story of this retired judge a few years ago who, the night before mediation on one of my cases, he sent a court case. He faxed it to both of us, so it was probably a while ago. I forget when, and he had annotated it. And the way he annotated it was clear that he didn't agree with my position. And this was before we even showed up to do mediation. And I was like, that was the last time I ever used a retired judge. But when you go to attorneys, it's the same thing. I have always been compromise minded. I always tell people I'm a professional problem solver over being an attorney. And I've done that since the first day I practiced. I hate going to court. I'm fine going. It's just more, you're dealing with judges who are overworked. They don't really read everything. They don't fully understand everything. I don't know how it is in Florida. They don't always understand the law here, because a lot of them came from like real estate or corporate or government or somewhere where they didn't deal with divorce and family law.
Sure.
They didn't deal with the dynamics of our cases, which is just as important as the law itself. And then, so for me, it was pretty easy because since day one, I've always been a big proponent of mediation. Like 20 years ago, I was trying to convince people to go to mediation and not file complaints for divorce. But, that's kind of, people are doing that more now than they did 20 years ago.
Right.
But for me, it was really easy because I hate fighting, but I love helping people resolve their problems. So whenever I started to mediate, we do have a program in New Jersey where you can get a certification for mediation. But what it's for here is we have a mediation program through the court system that's part of a divorce that you have to do. So to get on the rosters to do that mediation, you have to go through a 40-hour course and mentorship.
Okay.
But you don't have to go through that if you don't care about being appointed by the court. If you just want to mediate for people, anyone can do it. So for me, it wasn't hard because I already felt that way. I already felt like that was the best way to proceed. I mean, I'm still to this day, I don't handle a lot of non-mediation cases, but I do some if the attorneys in my firm are like a little overextended, and I try to help out. Right. First thing I still do is pick up the phone and call the other attorney and be like, okay, what do we need to do so this case doesn't blow up, so that we can keep it on track and we get these people divorced quickly? And it's still amazing to me. Only about a third of my adversaries, actually work with me to do that. Most of them are like, well, we need to do full discovery. We need to do this and we need to do that. I'm like, they're W-2 employees. They've been married for 4 years. We do not need 4 years of bank statements. Like, what are you talking about? This is dumb. So it wasn't hard for me, but a lot of attorneys that mediate have a hard time mediating, but they think they need to now because that's the movement. As we're going more and more to ADR, so everyone thinks they have to mediate. Well, it's just like being a litigation attorney. Like, if you're not good in trial, like if you're not good with rules of evidence, you're not you can't multitask and listen to testimony while looking at something. If that's not you, then don't do it. You're going screw up someone's case. The same thing goes for mediation. You can screw up more cases by not knowing how to mediate than you can any other way. Because the second you say one thing to one party that tips the scale, you might have just done damage to the case that's hard to reverse.
Right, right. So as a mediator, how do you prep for mediation? How do you prepare for the mediation?
So I do, there's two kinds of mediation that I do, and I prep a little bit different. The first one is pro se people coming in at the very beginning. They don't have attorneys. They hire us together just to do their mediation. It's like we have a package. It's a flat fee package. So those people, I don't usually have them give me anything in advance at all. Because I want to, since they're already on good terms, they've already come in, they're already, willing to sort of cooperate. I don't want either one of them to accidentally say something or submit something that would upset the other person before we even get started. So with those people, I give them a list of things to have available, so they don't have to start look like their pay stubs and their W-2s. And I do tell them, like, listen, if you guys are comfortable, start talking about really easy things, like maybe holiday schedules for the kids or things like that.
Yeah.
And then, so for them, I just, first mediation session, I spend the first 20 minutes getting my biographical information really quick, and then I dive right in. Now, if there's an attorney involved, I absolutely want them to submit something to me in advance, just telling me what their position is.
Okay.
And explain to me sort of why that's their position. And then but the reason I do that is not so I can be super prepared for mediation, because I'm sure you probably feel this way. At this point, we're well north of 2,000 divorces at this point. So there's nothing that anyone can possibly say to me that I haven't already seen before. So it's kind of like, I feel like it's almost like being an ER doctor. Whatever, you bring me anything, I'll figure it out really quickly. I don't need to prepare for hours and hours. And I get really concerned when mediators, I see on their billing that they spent 3 hours preparing for mediation. I'm like, but you're not
There's
a
nothing
judge.
to prepare for.
No, you don't even know what the real issues are. You really don't know. And that's why I hate attorneys be involved in mediation, because they're advocates. They're giving you their position, but I really want to know, no, okay, screw your position. I don't care what your position is. What do we need to do to help these people get resolved?
What's the end goal?
I know. Do I need to go in? Do I need to take one of them into a breakout room and literally tell them, you're never getting what you want? Okay. You're never getting it. It's never happening. So do you want to actually get this resolved, or do you want me just to tell them, you guys are just going to trial and go give your attorney $50,000 right now?
Sure.
Is that what I need to tell your client? Or, where are we? And that's why attorneys muck it all up. And as an attorney, I sometimes laugh when I say that, but it's true. We muck it all up. And the people that come in without attorneys, our flat fee program is 3 hours of mediation. So it's built in mediation. If you need more, then it's just hourly after that.
Sure.
I'd say easily 2/3 of everyone comes in, I get it done in that time frame, because it's interesting. It's like everyone has the same motivation. The people want to save money by not going beyond those guidelines,
Right.
and they're both motivated. So they both make good decisions based upon cost benefit, as opposed to fighting. And most of the time they don't have the emotions involved. Although, people fight all the time on mediation.
Sure.
I'm used to being an adult daycare to some extent. That's fine.
Right.
That's fine. I'm sure on mediations you do the same thing. At some point I'll let them fight for a second, and then I'm just like, I'll mute them, I'll do whatever. I'm just like, we're done.
Yeah.
But yeah, so not a lot of prep. Just very. I want everyone to come in open-minded. So the less they see in advance, the better from the other person.
Yeah. So for me, I love mediation, because for me, I've said forever, I love it because there's no prep and then there's no homework. Like, you're going in with nothing and you're leaving, and when you're done, with or without a resolution. When you're done, you're done. which I like. And just like you, I mean, I do pro se, I do, as well as with attorneys. And with the pro se, I always, pro se, they'll be like, do I need, should I talk about things before? Should I not? Like, and I always tell the same thing. I said, what is most important, number one, is not whether or not you communicate, it's how you communicate. So communication's great. Just watch how you communicate. But number two, at the end of your communication, make sure that you clarify whether or not Matthew and John had a conversation or whether Matthew and John have an agreement. Because like you and I could have a conversation and you walk away going, wow, that was a great, time with Matthew. I really learned a lot and I was able to express my opinion and we had a good conversation. And I could walk away going, I have an agreement with John. Then they come to mediation and it's like, well, we've agreed. It's like, no, we didn't. It's like, yeah, remember when we met and we had we were talking about it? It's like, yeah, we had a conversation. So I always warn everybody, make sure that at the end of whatever you're discussing, make sure that you understand whether or not you have come to an agreement or it's just a conversation. Otherwise, that can cause problems when we get to mediation. So be careful about how you communicate and then also clarify what is it that you're doing.
Oh, absolutely. I mean, I hear that all the time. We've already agreed, and then the other person's like, no, we didn't. We were talking about that. Yeah. I mean, that's why I really don't want them to talk too much. I mean, I figure they're hiring me to do the heavy lifting, and I'm willing to do it.
Yeah.
I'm happy to do it. But it's easier when you have someone guiding you. All right, here's what we're going to deal with first. Like, I don't know how you are, but I always deal with children first. I don't even talk about money until I make sure that the parenting plan and the custody schedule, everything looks good. Then we start talking about money.
Yeah. We actually go with I don't know if it's a Florida thing. I don't know where it came from, but we go in the PEACE acronym, PEACE. So parenting, then equitable distribution, then alimony, then child support, and then everything else. Because, as equitable distribution, well, it could be based on like, what are we doing with the house? Depends on maybe what we're doing in the parenting. And then alimony, well, alimony has a look back to equitable distribution and parental responsibility. Child support looks back at then the parenting plan. So we go in that order because they have look backs, but also it seems to build momentum and consensus, and then of course we're focusing on the most important thing because, as you had mentioned with the, with the courts, the judges a lot of times rely on the attorneys for directions. Like, well, so, how, like, give me case law. Wait, you don't know the case law? Like, you want me to give it to you to give you direction? And they don't want to deal with the kid issues. Deal with equitable distribution. If you're an equitable distribution state or community property, fine. It is what it is. We're done. It's those little intricacies with family that they're like, yeah, I don't want to get involved in that. I will if I have to, but I don't want to. And so they really rely on the mediators to like do your best and try to get through this because we don't want to get involved. We will if we have to.
Yeah, well, I mean, the good thing about most people that come in right off the bat for mediation is they almost always, when it comes to those issues in terms of alimony and equitable distribution, equitable distribution, it's always one of two things. At least this is what I see day in and day out. They either both are agreeing to keep everything that's in their name, or they just agree to split everything 50-50.
Or sell it all.
So I'm with you. It's really, that's an easy thing to get them to agree to. I mean, sometimes there's some wrangling over the house in terms of how it's going to be divided, but
sure,
that's what they deal with. Alimony is interesting. Again, it's one of two things. One is they agree that there's not going to be alimony, or two, they agree there is going to be alimony, but they have no idea
how much or how
long. And then they ask me, and I talk to other mediators about this all the time. And I've told people, in that circumstance, if they come in and they're like, okay, listen, we both agree there should be alimony. We have no idea how much it should be, how long it should be. In that circumstance, it's one of the only times I'll do this. I will give some ranges. I'll say, listen, if you were asking me in my 23 years of doing this, what would be an acceptable range for alimony in a case like yours, here it is. Which I know is not all mediators will do that, but I figure if I don't do that, they're not going to resolve this.
Sure.
I mean, I try to get them to give me numbers. I mean, I only do that if I can't. I'm like, okay, well, what number do you think would be good? And sometimes they're like, we just don't know. Whatever's fair, whatever you think is fair, John, is fine with us. I'm like, well, that's not really my role, but
and it's not what it's based on.
Yeah, but seriously, if that's the only way to move the needle, and they're both asking me for it,
right? Right.
They're both. If one of them's like, no, don't do it, I won't give them a range.
Sure.
But if one of them are like, please help us, then yeah, I'll give a range, because otherwise, how are they going to resolve this? Then you're going to tell them. I mean, most mediators will be like, well, you need to go talk to an attorney first. Again, the second you introduce that attorney, if it's not totally necessary, I mean, listen, there's situations that are necessary. If someone has a closely held corporation, or if there's MSUs that I don't really have enough information to talk about, or if there's hidden money somewhere, if there's situations where I'll send people to attorneys and say, okay, you guys can come back. This doesn't mean it's over.
Right.
If it's like alimony, we all know if you're the payor, you're going to be given, a rosy picture by an attorney. If you're the one getting alimony, you're going to be told, here's the maximum amount you're going to get.
Sure.
How's that going to help at an early stage mediation intervention? It's just not going to help. It's just going to be, yeah, okay, fine. You're told the max number, you're told the lowest number.
Right.
I just give them a range that's kind of like middle of the ground, kind of the median of what, we have like rules of thumb here. They're not based on statute, but we have rules of thumb that our appellate court says you're not allowed to use, but we all use them anyway.
Sure.
Otherwise, it's hard to resolve cases.
Yeah. We had the same thing, like rules of thumb, until 2023. And in 2023, just 2 years ago, we now have an exact calculator just like child support. And so we take the income, we put in the date of marriage, the date of filing, and it spits out the maximum duration, the maximum amount. But you've got to get through the statute, which talks about, okay, first you've got to get through need and ability. If you can prove need and ability, then you've got 13 factors. Well, if you can get through the 13 factors, then you have the calculator. The problem is, just like you said, like, a lot of attorneys, they'll jump right to the calculator with the client and go, well, this is the maximum amount, or this is your maximum exposure. The problem is, okay, have you gone through need and ability? Have you gone through the 13 factors? And the way, John, it's funny, the way that I've equated to people is okay, so fine. You want to go to a sports game, so you buy a ticket for a seat. It doesn't mean you're getting in. Like, you first have to pay for your parking. You got to get through the parking lot. There's your need versus ability analysis. Then you got to get through security. That's all your 13 factors. And if you can get into the parking lot and get through security, now you can go sit in your seat. And so, but at least, I mean, I've been doing this for 18 years, and up until 2023, I always equated it to, I said, this is like we're going to go to Costco and we're going to clear it out. And we're going to put a dartboard on one wall, and we're going to blindfold you and twirl you around. Okay, throw your dart. Let's see if you can hit something. And because it was a total shot in the dark, we're like, well, maybe, sort of, kind of. We had our rules of thumb, but it wasn't until 23 that we finally got a calculator. So in Florida, actually, and things really got real easy in family law in 2023. Because in Florida, for parenting, there's a rebuttable presumption of 50-50. Okay. And if you don't like it, there's 20 factors you can go through. And if you can prove up all 20, and if the judge can make specific written findings of all 20, maybe you can deviate from 50-50. Unless, of course, it's not logistic. Like, okay, John lives in New Jersey, and, your spouse then lives in Georgia. Okay, well then, no, you can't do 50-50, right? Like logistics. Then when you go to equitable distribution, date of marriage, date of filing is 50-50. Okay, that's sort of simple. And then alimony, we now have a calculator. And then child support, we have a calculator. And then usually attorney's fees, well, that's the same analysis as alimony. So if you can get through need and ability, then maybe you get fees. So a lot of the times the attorneys, and as a mediator, I tell people, I say, look, if you can't figure this out, this is really easy for the court. Really, really, really easy. 50-50, 50-50. Child support is what it is. Alimony, that's your burden of proof to prove up. Or what do you want to do? What do you want to do? You can do anything you want. Ignore me, ignore the law, ignore the statute. What do you want to do? And so a lot of times, like especially like with pro se, it's like, well, just like you said, we want to sell everything, we want to split everything, but I mean, like, how do we do this and how do we do that? And so it's almost like we, as mediators, we reverse engineer it. We're like, tell me the end game. Okay, now it's easier to say I'm going to get from New Jersey to New York City. Okay, fine. But if I said, okay, well, John, I'm in New Jersey. How do I get to New York? Man, we could be sitting all day long arguing what's the best path to get there, right? Who cares? We're going to be in New York City. Reverse engineer it.
Yeah. No, it's absolutely, that's how you have to do it. And I'm kind of jealous that you guys have so many, like the alimony calculator. You've also got the rebuttable presumption of 50-50 on custody, because we don't have any of those things. And it's funny, there was a movement to try to do that with alimony, because some others up here have it. Like I know Massachusetts has
Massachusetts. Yeah. We actually modeled Massachusetts. A couple of years ago, Florida's been trying to get an alimony calculator since, I think 2016, I think is when I remember it. The problem though, John, was they kept trying to bundle an alimony reform with parenting in one bill.
No.
Well, then they're trying to add a retroactivity to alimony, which then is unconstitutional. So they veto it, but then you lose the 50-50 time sharing. And they kept trying this with different governors and different things. And so actually there was an attorney, his name's Matthew, up in Massachusetts. I interviewed him years ago and said, okay, how did you do it? He was the one that spearheaded it. I was like, how did you do it? So he was explaining to me how, and that's basically then, and Florida was modeling how Massachusetts had done it, but they finally in 2023 was the first time since I think 2016 that they finally separated the bills and did a parenting bill and an alimony bill, and they both passed. And it's like, well, done. Stop throwing money and kids that have nothing to do with anything into one bill and trying to get it passed. But we've only had that for about 2 years.
I'm jealous. I mean, we tried to in New Jersey. It went back and forth. The Bar Association, the family law section was against a calculator.
So was ours.
Reason it actually harkens back to what I've already said, which is
they want to fight.
Yeah, they want more data points to fight about. And but so our reforms were surface level. Like there's now a cap on the duration of alimony for any marriage under 20 years. There used to never be the cap. People were married for 13 years paying lifetime alimony. It was absurd. We have more the statute, like there's actually a statute now for cohabitation. Before it was just case law.
Okay.
That sort of stuff. So it really made it a little bit better, but it still isn't great. And then of course, everyone's still struggling since the last tax bill got rid of the deductibility of alimony. Yep. That really impacted a lot of what we were already doing here. So I still think people are struggling over that. They still don't really want to take into account the tax impact, like net incomes, because we were so used to dealing with gross incomes. I still hear people all the time using gross incomes and taking some percentage. I'm like, but you can't do that. Like that's not real. That's not reality. Reality is how much money do you have in your pocket after taxes are paid. So there's just so much that we still have to fight about all the time. But what I find very interesting, and probably what no one will ever tell most people, is that the wealthiest clients a lot of them have the easiest divorce processes because they understand. I mean, they might have a lot more.
For more information about my services or to schedule your mediation with me, either in person or using my iChat mediation virtual platform built by Cisco Communications, visit me online at iMediateinc.com. Call me at 561-262-9121. Toll free at 877-822-1479, or email me at mbrickman at ichatmediation.com.